You're welcome to the show. This afternoon, it appears the nation is inching closer to what actually happened with the demand guarantee, on which basis Ghana handed over Electricity Company of Ghana assets worth over $3 billion to a privately owned entity, Power Distribution Company, PDS. JoyNews can confirm findings by the government delegation sent to Qatar to verify the $12.25 million demand guarantee posted by Power Distribution Services show that Al-Koot did not issue a valid guarantee on behalf of PDS. We'll look at that report vis-a-vis another report commissioned by the Millennium Development Authority. As it stands now, you know that government has suspended the concession agreement with the electricity distributor since July 30, after it says it found breaches in the demand guarantee. Head of Investigations here at JoyNews, Malik Abbas Dabu, will join me, as well as Evans Mensah. Ahead of that discussion, though, here is a news desk report in which we highlight the key issues.
We have not identified any information to suggest that either PDS, Calbank, Danwell and/or personnel from MEDA committed or conspired to commit fraud or other malfeasance in relation to the demand guarantees. A direct quote from the investigative report commissioned by the Millennium Development Authority into the PDS scandal. Government had suspended the concession arrangement with the PDS after it found breaches in the demand guarantees, a prerequisite for the concession agreement. The MEDA commissioned report, exclusively secured by JoyNews, say PDS, Calbank, Danwell and/or personnel from MEDA had no basis to question the validity of the payment securities as of March 1st, 2019. Qatar-based insurance firm Al-Koot had rejected the validity of the demand guarantees, claiming the officer who signed the deed was not authorized to do so. The report also details how the conditions surrounding the demand guarantees approved by Parliament were changed with the approval of the Vice President, Dr. Bawumia. The investigation also showed that ECG wrote to the Attorney General seeking urgent confirmation of whether there will be the need for cabinet approval and parliamentary ratification for the amendments to the transaction agreement and document as a result of the changes. The report says the Attorney General's opinion letter, which was received on March 1st, 2019, implied that there was no need for cabinet approval nor parliamentary ratification. One major question now remains, with insurance firm Al-Koot still maintaining that the demand guarantees are not valid. What happens to that critical condition precedent that required PDS to have a demand guarantee as a primary basis for the concession arrangement?
Well, already the minority in Parliament has been raising questions about aspects of that report. The report indeed also found that PDS used revenues collected from customers to pay off a $7 million loan that they had taken to settle fees for raising the payment securities, which was a condition for the concession arrangement. So we're doing more analysis. Like I said, my colleague Malik Abbas Dabu has joined me in the studio with those details now. We'll also show you some graphics, which highlights, again, the key points. Malik, it's good to have you. How are you doing?
Good.
All right. So before, I'm not bad at all. Before we go in there, let's take a look at what our graphics show our viewers so that we can carry on with the conversation. So this is essentially the terms of reference for the government team that went to Qatar. Now, they were supposed to ascertain whether or not Al-Koot authorized the issuance of the guarantees on behalf of PDS and in favor of ECG. They were also expected to ascertain whether or not Al-Koot issued the type of guarantee PDS presented to government of Ghana. Now, the terms of reference continues with the fact that they were to establish whether Al-Koot ever issued any form of guarantee to ECG, and if so, whose authority was this done. They were also to establish whether Al-Koot had a guarantee in place for ECG as of March 1st or March 1, 2019. So, Malik, let's look at the terms of reference. I mean, we just put together there a bit of a highlight, but let's begin with who actually consists, or who and who make up the team that went to Qatar on behalf of government?
Yeah, you were right when you talked about 5-member delegation. It was a 5-member delegation led by Interior Minister Ambrose Derry. You know that he is a lawyer himself. The other person who was on this committee was the Deputy Attorney General, as is suspected, because these are matters that may have legal ramifications. So you had the Deputy Attorney General Godfrey Dami being a member of it. Of course, there was also police officers and police investigators. So ACP Frederick Eje, who is head of Interpol at the Criminal Investigations Department of the Ghana Police Service, was part of the team. And the Chief Superintendent Regina Inchua Tenge, she is the head of Financial Forensics. So look at the category of persons. You have 2 lawyers, one in charge of Interior, one in charge of Attorney General, one in charge of Interpol, another person in charge of Financial Forensics, and the last person was Tete Kujoji. Tete Kujoji is a special advisor to the finance minister. So these were the 5 persons who went to Doha, Qatar, to have meetings with Al-Koot to find out exactly what transpired and how it came to be that Al-Koot, who was reported to have issued these demand guarantees in respect of 2 documents, the lease assignment agreement and the bulk supply agreement. These were the 2 agreements in respect of which these demand guarantees were issued. Okay. And Al-Koot, which was supposed to have issued these, then subsequently wrote in July 31st saying that they knew absolutely nothing about these. And Al-Koot wrote because the ECG, which was supposed to be the beneficiary of these demand guarantees, wrote to Al-Koot seeking to verify and to confirm whether these were indeed demand guarantees that were issued by Al-Koot.
So they put together their observations, I mean, in this report that you have there, and you'll help us, see exactly how the report puts it, and then we can do some analysis. But again, for highlights purposes, take a look at what exactly their observations are in these graphics that we put together. So the observations indicate here, as you see, following the emphatic assertions of the top management of Al-Koot, led by its CEO, it is eminently clear that there is no valid payment security or demand guarantee issued by Al-Koot in respect of any part of the obligations of PDS under the LAA and the BSA. Further, the officer who purported to authorize the guarantees lacked capacity and did not have the requisite approval to execute a guarantee of such value. So these are sort of the highlights of the observations of the government team that went to Qatar, and Malik has details of that. Malik, run us through exactly how the report captures this part of.
So the government delegation arrived in Doha specifically on August 7, and they met with 6 executives of Al-Koot, including the chief executive and Al Musa, who is the general manager in charge of the insurance. Now, Al Musa, you have to know, was the one who wrote a letter in reply to the ECG letter saying that they had no valid demand guarantees issued by Al-Koot in favor of ECG as submitted by PDS. Now, when they met the Ghanaian delegation on this same day, because the Ghanaian delegation arrived on the 7th, that same 7th, they had this meeting together with the Ghanaian mission in Qatar. They met with the Al-Koot executive, and in that meeting, the Al-Koot executive went through some of the allegations that they had made in previous letters to ECG. One of them, which is what you just put out, that Al-Nouri was the manager in charge of reinsurance at Al-Koot. Al-Nouri was the one who signed the documents saying that there was this demand guarantee which was being issued in favor of ECG. Now, Al-Koot in that meeting pointed out that, first of all, Al-Nouri lacked capacity. And the reason Al-Nouri lacked capacity was that there was a limit that he could go in terms of approving these kinds of agreements. And that limit was $15 million. Okay. Now, he signed these demand guarantees covering an amount of $350 million. That is way in excess of what he was entitled by the constitution of the company to do. The other issue that they raised was that the entire assets of Al-Koot,
yeah,
if you put together everything, their financial worth is $170 million. So they could not possibly provide a cover for $350 million worth of cover. They absolutely couldn't do that because their worth is 170. They actually point out that the $350 million that they were supposed to provide cover for is actually 200 times their net worth.
So the entire company put together,
yes, their net worth is $170 million.
It's not even half of the amount they were supposed to be guaranteeing.
To provide cover for. So they couldn't do that. The other issue that they raised was that if you look at the constitutive documents of Al-Koot, Al-Koot does not issue demand guarantees. Beyond Al-Koot not issuing demand guarantees, there was no application before the company properly laid asking that they should issue these guarantees in favor of ECG and for PDS. That application was not before them. They indicate that in their own internal investigations, they found out that Al-Nouri, having exceeded his powers guaranteed by the company, did not bring the negotiations and the discussions before the board of the company as required by law. Because the law requires that the company's regulations require that if you want to guarantee any asset or provide cover for any asset beyond a certain limit, the board has to approve it. This did not come before the board at all. Of course, they concede that they had done some business dealings with Joe Australia. You have to note that it was Joe Australia that contacted Al-Koot to issue this cover in favor of ECG on behalf of PDS. Now,
it presupposes that there must have been some level of due diligence on the part of this Joe Australia company.
Well, Joe Australia has been doing business with Al-Koot already. So when Joe Australia contacted Al-Koot, they actually contacted the person who is in charge of what they were looking for. They were looking for reinsurance, which is Al-Nouri.
Right.
So Joe Australia, as far as they were concerned, the documents as issued were authentic. And this is the reason why, if you listen to Evans's report, which is on the basis of the FTI investigative findings, they say that these companies, Carl Bank, Danwell, Joe Australia, PDS, had absolutely no idea that whatever documents that were submitted did not have the adequate authorization. They had no idea at all. In fact, the investigators point out that there was a case in which a person acting on behalf of another company, like Al-Nouri did, exceeded his powers, but a court of law held that the company was bound by the decision of this representative who acted in excess of his powers guaranteed by the constitution of the company.
On which basis? Because of the business, the fact that they've done business over the years, and because, and that covers...
Yes, because in that case, what they said was that the other party, the party which relied on the cover which was provided, had no way of knowing that this person was exceeding their powers. Now, having said that, they issue a caveat that they are uncertain whether that is applicable in the instant case being the Al-Koot and the PDS saga, whether or not ECG can argue that to the extent that an official of Al-Koot was the one who executed these documents, the documents are binding on Al-Koot. So those were the issues that Al-Koot raised, on the basis of which the Ghanaian team came to the conclusion. So the chief amongst them, Al-Koot doesn't issue demand guarantees. Al-Koot could not have provided the kind of cover that was being provided because it was way in excess of the company's net worth. The person who signed did not have authorization. There was no board approval. They did not receive any payments, even though Joe Australia contacted Al-Nouri, who signed this document. Whatever money that was supposed to have come to them itself did not come. And so on the basis of all of this, they say there was no valid cover issued by them on behalf of PDS in favor of ECG.
So we'll talk about the fact that what this report says and the implication that it has on the outstanding matter, or the issue that issue that's at hand, for which reason they had to go to Qatar. But let's just bring into perspective the FTI findings and how it compares to this particular finding. The FTI indicates that there is no fraud. But when you say there is no fraud, vis-a-vis what we know of this the government delegation's finding, what conclusions can we arrive at?
I think if you look at the 11 conclusions and the FTI findings, there are 11 conclusions that they draw. If you look at those 11 conclusions, you would see that a lot of them mirror with precision, with exacting clarity, the observations that have been made by the government committee, i.e. that there was no excess, there was no capacity on behalf of by Al-Nouri, there was no capacity by the company, the documents were received. The point of departure of fraud is that Al-Koot is the one claiming there is fraud. The FTI findings say they have no proof of this fraud, and that Al-Koot has not given them any proof that fraud was perpetrated.
When Al-Koot say that there is fraud, they are indicating that the person who signed it, is that the basis? Their official had no authorization to do so.
Absolutely.
Is that the basis on which Al-Koot says that there is fraud?
Yes. Al-Koot's argument is that the demand guarantees that were issued because they lacked authorization, their official who issued them fabricated, in some instance, actually fabricated a signature of the chief executive who was in charge of this documentation.
Okay.
That there was a letter, anytime letters came from either PDS or ECG, he intercepted them. That they didn't get to the top hierarchy of the company. You have to note that he himself was placed in order to be able to deal with these matters, because these demand guarantees bordered on reinsurance, and that's what he was responsible for. It was on the basis of his acting without authorization or in excess of his capacity and the powers granted him by the company that Al-Koot argues that there was fraud.
But the FTI
argues that as far as they are concerned, this is Al-Koot's allegation. Al-Koot does not back that with any evidentiary proof that there was fraud. As far as they know, Al-Nouri is an executive of Al-Koot. He was placed to deal with reinsurance. He issued the documents and signed them. Well, they say Al-Koot argues that he acted in excess of his capacity. But they can't tell conclusively if that constitutes fraud. It is the reason why they quote that cassation case in which somebody who acted in excess of their capacity and acted on behalf of a company, the company was held to be bound by his actions.
By his actions. So is that the reason? Isn't it because FTI actually looked at investigations, the investigations focused on PDS, focused on the role of ECG, and that they did not really get access or have access to Al-Koot, as they say in the report.
That's true. They point out that Al-Koot did not really cooperate fully with them. Of course, they gave them some documentation on the basis of which they drew the conclusions that they drew. But they emphasized that on the basis of those documentation, they could not state conclusively that there was fraud, because all the documents that were submitted, and one of the points that you would hear Evans make in his report, the demand guarantees that were covered were actually in conformity or in compliance with the requirements of rules of demand guarantees. And that on the basis of that, nobody could have doubted the authenticity of these guarantees.
At the time it was
at the time that they were presented to the ECG by PDS, that their authenticity could not have been doubted because they were duly signed by a recognized company, which is, recognized to have the capacity to deal with this. The other issue about Al-Koot not issuing demand guarantees, the FTI says that, well, they have not seen any documents by Al-Koot that specifically prohibits it from issuing demand guarantees. Therefore, they can't really challenge Al-Koot's claim that they don't, by the nature of their business, they don't issue demand guarantees.
But one point is clear, that there is no, as we speak, enforceable demand, demand guarantee.
That's what the government team is saying.
And
that on the basis of what Al-Koot says, they think that there is no, they believe, they hold a view that there is no enforceable cover, enforceable demand guarantee cover for ECG as presented by PDS.
And if this position holds, then at the end of the day, what it means is that there is not supposed to have been any concession agreement at all, because the basis for that concession agreement was that you are providing some guarantee, you're providing a cover. So if in the absence of that cover, there is no concession at all.
Yes, so if there is conclusion on the matter that this cover which was presented was vitiated by either fraud or by lack of capacity and all of that, then you may make the conclusion that you make. Does that conclusion mean that is it so fundamental that it brings down the whole concessionaire agreement? We have to see. The lawyers have to pronounce on that. Otherwise, one could argue, well, if they presented demand guarantees or insurance covers that were not satisfactory, how do you remedy that situation? I am sure that if we were to read the provisions of the agreement, we will see whether this breach is so fundamental that it virtually collapses the entire agreement, or it is a breach which can be remedied, i.e., could PDS go back and do the right thing, provide the cover that was supposed to cover, and then they can continue with their business. So these are matters that the lawyers acting together with the state, represented by the government and ECG and PDS, can then look at it and determine what does the provisions in the agreement allow them to do. Can they remedy this situation by going back and providing the cover that they ought to provide, the cover satisfying all the provisions that it ought to satisfy, so that there can be reasonable comfort that if ECG one day wakes up and PDS does not perform, which is the reason why these demand guarantees are required. I think it's important for us to explain why these demand guarantees are required. These are just performance guarantees. That says that ECG takes over the assets of, PDS takes over the assets of ECG.
Worth over 3 billion,
it will do X, Y, and Z. That they will set aside a certain amount of money, that any day they are unable to achieve the things that it says they will achieve. If there is need for ECG to spend any money, ECG can tap into that amount, sometimes even without recourse to PDS, for whatever obligations that PDS was supposed to execute that they couldn't execute. This is the purpose for which they are supposed to provide this demand guarantee.
And it's important, Malik, because we look at the worth of the assets. You don't, these are not assets that you just, give away. And that's why we needed that. For Ghanaians who rely on power. And everybody sounded a bit excited at the beginning when they said, well, there's private participation in power distribution. What it means is that are we going to get better services for those Ghanaians who are following this discussion, who may not have followed all the nitty-gritties of the investigation and whether or not there's fraud, etc. What do you think should be the sticking point for them?
I think the sticking point is the people who have been mandated to deal with these matters may have, there must have been a certain lapse in judgment at some point in time, but they have remedied that situation by going to do all the checks that they ought to have done. If you read the FTI findings, you would see that at some point in time, the advisor to the finance ministry told ECG that in order to confirm whether or not this demand guarantee is authentic, use some other contact other than that which has been provided on the agreement and contact Al-Koot and find out from them whether or not they issued this guarantee, whether it's valid, and whether there are any issues related to that.
Which is why we are where we are at the moment.
Which is where we are. Otherwise, if they had used the contacts that were existing on paper, whatever correspondence they sent would have fallen in the hands of Al-Nouri, the person whom we are being told by Al-Koot, and note that these are Al-Koot's claims. They have not been verified by any independent person, and Al-Koot actually claims that they suspended Al-Nouri. They say that when Al-Nouri was first confronted with this, he denied knowledge of this demand guarantee. Subsequently, when there was sufficient documentation and proof that he indeed signed this agreement when he was approached by Joe Australia, he considered that yes, he did it, but claimed then that Joe Australia misled him. Of course, all of these are claims being made by Al-Koot. We have not heard from Al-Nouri. Al-Koot says that when they conclude their internal investigations, they intend to report Al-Nouri to the Qatari police. Of course, Al-Nouri is under suspension on the basis of this. In fact, Al-Koot says that they reviewed a number of transactions that they had with Joe Australia, and they found out that some of those transactions themselves had problems. And again, they were all transactions between Joe Australia and Al-Nouri.
Interesting findings there, and it looks like it's not done yet. As it stands now, that concession agreement has been suspended, but there has been some sort of agreement between PDS and ECG so that, power distribution could still go on. And that's where we are right now. But there's still the question that has to be answered about what happened to that demand guarantee. And you've heard a lot of the explanation from Malik, who has a report from the government delegation that was sent to Qatar to investigate this matter. You also heard from the FTI investigation. The FTI investigation was commissioned by MEDA. There's more on this at myjoyonline.com. Take your time, and if you're interested in all the nitty-gritties, look at it. But if you're also just interested in having power in your home, having power in your business, at your office, or to do your business, you still have to be interested in this. And Malik has given you a bit of an understanding, so you can follow the discussion. Malik, thank you very much for coming with that. Malik is head of investigations here at JoyNews.